I'd like to welcome you to the Reapportionment and Redistricting Committee meeting. This morning we've got a packed agenda and a very small amount of time to get going. We're going to have two bills presented. We're going to vote on two bills. So because of that, we've got to limit the conversation and discussion about those bills. I'll go ahead and first thing I need to do is we need to approve our rules.
Madam Chair, when you're ready, I make a motion to pass on the rules.
Okay, I have a motion. Do I have a second?
Second.
All right, the rules are approved. Let's
vote.
Oh, I'm sorry. Yes, let's vote on those rules.
All in favor?
All in favor? Raise your hand, please. All right, very good. Thank you. All right, let's go ahead and get started on the first bill. Is 124. Are you more comfortable at a chair? Have a seat, that's fine.
Madam Chair, members of the committee, I appreciate the opportunity to be with you today. I'm going to silence my phone so I don't have a practical joker hit me while we're talking. Senate Bill 124 I bring before you today as a practical matter, as a belt and suspenders issue. Historically, and I've got in your packages as well, I've got a copy of Article 9, Section 2, Paragraph 1 of the state constitution, which speaks to this issue of the home rule powers of county governments. We've got case law and we've got the plain text of the Constitution that has been fairly clear, I think it's been exceedingly clear, that counties do not have the power through their home rule powers to draw districts for themselves in counties where as most counties, you've got county commissioners that are portioned in geographic districts. The powers never existed. Power doesn't exist. However, unfortunately, in my home county, Cobb County, this last October, in spite of the Constitution and the statutory framework and the case law that would suggest to the contrary, our county attempted through their home rule powers, and counties, as you know, do have some home rule powers. They attempted through their home rule powers to override the duly enacted county commission district maps that was enacted last year by our legislature, signed into law by a governor. And their goal was to set that aside and interpose their own map that would be the commission map moving forward for 2023 and the rest of the decade. There is no power to do that, but to confirm that there's no ability for other counties to try to propose that. As you know, it's very expensive in litigation on a case-by-case, county-by-county basis to try to stop that from happening. You literally are going to have to work your way through the court system to try to keep this, what I think is an unlawful and unwarranted power from being able to put into effect. Citizens literally have had to try to litigate to stop this, and you step back and ask, if it's been the constant standard for our state, Madam Chair, and members of the committee, that counties cannot apportion their own districts, let's clarify in law, let's make it crystal clear, pursuant to our Constitution, and the Constitution's giving the General Assembly clearly the authority to limit, circumscribe the county's home rule powers, to make it crystal clear counties do not have the power to apportion themselves. Only the General Assembly through local act or statewide act can do that. So that's the bill before you, HB or Senate Bill 124, and be happy to take questions, Madam Chair.
He said HB, didn't he?
SB.
SB 124, yes. Bad habits are hard to break, man.
Okay, does anyone have any questions?
Isn't this already codified in law?
It's
What number are you?
Let me put on my dollar store glasses here.
number 10.
10. I'm sorry. I was just curious, isn't this already codified in law? Or are we just doubling down on what's already in law? Just clarify that for me.
Madam Chair, to my friend and neighbor from Cobb, I think it's very clear. If you look at the last page of this handout that I added to the committee, it says case law. The Bodker case says General Assembly is the only legislative body with the power to enact redistricting legislation for counties. Therefore, the General Assembly, it goes on. That has been the constant stance of the state. There's been the constant understanding of our counties. It's only when our county senator tried to create this purported power and actually interpose a state-passed map with a county map using their home rule power to override this precedent and this understanding that this bill looks at sections A, B, and C of paragraph 1 and says the General Assembly, by general law, has, again, the power granted to counties shall not be construed to extend to the following matters or any matters which the General Assembly by general law is preempted or may hereafter preempt. We are specifically preempting counties from having their home rule powers extended to include county district reapportionment. We've got the Constitution gives the General Assembly specific power to preempt, limit, change, circumscribe, otherwise counties' home rule powers, and we're doing that here to clarify. So other counties, like unfortunately our county's attempted to do, is to try to assert this power. This bill would clarify without any discussion that power does not exist. That's all it does.
I have another question. It might not be for you, it might be for a legal person. What happens if a person is in office? You know, we have 2 terms. Some people have 4 terms, and then you draw a map and draw them out of the district. Is there any provisions to allow them to continue to finish their term instead of them having to leave their position because they were redistricted out?
Take number 6.
So, state law, OCGA 4551 provides that if a person who is elected from a district no longer resides within that district, that creates a vacancy in the office. That code section then provides the procedures by which that office can be declared vacant. So the Supreme Court has held it's not an automatic vacancy, but there are procedures that can and probably would need to be followed if a person no longer resided within the district he or she was originally elected from.
Okay, if there are no more questions, do you have? Who had a question? What number are you? 4?
My question's for Legislative Counsel. Stuart, can you clarify that a little bit more? So walk me through the scenario. You're in 2000 and, let's use different years. We'll make it 1998. You're elected to a term that would serve you through 2002. In 2000, we have to redistrict. I guess obviously the map doesn't pass really till 2002, but if it passed in 2001, what happens by practice, I guess, is though there's not another election until 2002, correct?
Yes, sir.
Okay, so the person's able to serve that year?
When we're dealing with county commission seats, unfortunately, there's just not a lot of great case law to interpret how this would happen. The closest analogy I've been able to find is back in the late 80s, early 90s, there was the General Assembly de-annexed a chunk of the city of Villa Rica, and residing within that chunk of Villa Rica was the mayor of Villa Rica, and he attempted to try and remain in office because the de-annexation happened in the middle of his term, and ultimately the Supreme Court ruled that no, the de-annexation resulted in him losing his office and creating a vacancy in the office as of the date the de-annexation went into effect. I'm unaware of any similar situation happening at the level of county commissioner level, so how such an issue might play out in the courts is not completely clear.
Thank you. I guess then that does show that we might need some clarity then on this topic. Thank you.
Thank you, Madam Chair. My question is to the author of the bill. Is this not a local issue that should probably be handled with your delegation?
Well, this, to the lady's question, this is a statewide issue that has relevancy in 159 counties. Now, there's another bill coming here in a moment that if the chair chooses to take up, would address a specific issue relating to specific maps. Glad to address that then or now. But 124 is the broad question of, can counties apportion themselves or not? This simply says it's the narrow question of, can county commissions reapportion county commission districts, or is it the state's sole prerogative to do that through the General Assembly? That's all 124 does.
Another question. So, is this the issue that was or is in litigation?
There is no current litigation undergoing. There was a case that was filed near the end of the year under the existing framework, where the county commission was asserting they had home rule power. There was a citizen brought a case to keep that from going into effect on January 1st because, again, it was broadly recognized as sort of cravenly unlawful that counties could try to use this power that's never been done by any county ever before and assert it. That lawsuit was filed. They had a hearing on a temporary procedural motion. That lawsuit was withdrawn. And there may be litigation that I'm not aware of, but this bill seeks to address that issue so that legislatively we can address this clearly without there being chaos in the courts, without individual private members trying to sue on behalf of the state's General Assembly's power to apportion. It doesn't seem to be the responsibility of a citizen to do that. So we can clarify here that no county can follow. The other 158 counties can't follow what Cobb County, this novel concept that Cobb County developed this last fall. That's all this does.
Madam Chair, just a point of clarification. 121, just all you're doing is restating what is said in the Georgia Constitution and codifying it into Georgia law. Is that correct?
And is overwhelmingly believed to be existing law.
Right.
And has only this last year been ever challenged.
Right. So this is not Cobb specific. This is 159 county specific. Is that
159
correct?
counties.
So this impacts the entire state of Georgia.
Yes, sir.
And then the other piece of legislation that comes up, I think SB 236, that one is Cobb specific,
Cobb
correct?
specific, yes, sir.
Okay. So all we're doing on the first one is just saying state law is this and laying that down, correct?
Making it very clear that what has been believed to be law is indisputably the law statewide, all 159 counties.
Thank you. Madam.
Okay, because of our time restraints, I can have two people speak. The first on the list is Bryant McDaniel. You'll have 2 minutes, and you can come over here to the podium. And then Fair Districts Georgia had a few people sign up, so y'all pick one, and one of you can have 2 minutes.
All right. Thank you, Madam Chair and committee senators. First off, thanks for giving me the opportunity to share my thoughts and concerns about SB 124, and I'm going to take some liberties with SB 236 as well. My name is Bryant McDaniel, and I reside in the disputed area of East Cobb, which is District 2 or District 3, depending on which map you use. I'm not an attorney nor an activist, just a concerned, independent-minded constituent. I'd like to address my concerns from a tactical perspective by looking at the likely consequences of these bills in Cobb County in the near term, but with an eye to the rest of Georgia over time. Specifically, my concerns about both bills revolve around the implications for our future elections and our representative democracy. These bills will only serve to make things more problematic and confusing as we go forward, and there is a need for home rule to cover this. My first concern is, how can voters trust a governing body that would approve of a map that draws a duly elected representative out of their office in the middle of a term, that could leave almost 200,000 citizens unrepresented for the better part of a year, that could bring a lot of the county business and business of the county to a standstill or at least disrupt it, and would require the huge taxpayer expense of a special election. This will only serve to undermine our representative democracy by nullifying an election and the voice of the voters. If this could happen again, why would anybody in their right mind ever bother to run for office, especially given the great amount of time, effort, and fundraising that's required? And for that matter, why would we as voters bother to vote if our votes can simply be nullified after a free and fair election? To use a football analogy, it feels like the goal line's been moved or the game's been called at halftime because somebody doesn't like the way the game is going. My second concern is that the map that's been in effect for the past several years seemed to be working just fine for most residents, but I'm left to wonder when you look at the old map and the proposed map of HB 1154, how did D2 get flipped over onto the I-75 corridor? We hear a lot of terms like communities of interest thrown out, but obviously the I-75 corridor has been there for some time. It's not a new concept and it's not a new issue.
Sir, your time is up. I'm sorry. Okay.
Thank you.
Thank you. Fair Districts, Georgia, who you got? You have 2 minutes.
Thank you, Madam Chair, members of the committee. My name is Ken Lawler. I'm the chair of Fair Districts Georgia. We're here with many folks here today to speak about the bill. Fair Districts Georgia, we're the only nonpartisan group that focuses exclusively on redistricting issues in Georgia. We oppose SB 124 because it really runs counter to the idea of home rule as applied to redistricting. We've articulated 4 specific principles around how local redistricting should be handled to empower counties. Number 1 is that the plan should be drawn at the local level. We already have the safeguard of the LCRO team that checks those plans for accuracy and for legality. Secondly, citizen input should be taken into account, and that happens best at the county level in front of those commissions where they have hearings, and counties did that last year. Third is that the local delegation should sponsor those bills as they have and brought them to the legislature, but the local delegation should respect what the county wants. They should work with the county and respect that, and in many cases that happened. And lastly, the General Assembly as a whole should defer to the local delegation. Use your local consent calendar model, which you have done. When we looked at what happened last year, almost all the counties, all except 4, that process worked. Whatever the law is today, the process worked. 150 some counties, their bills were passed under local consent, legislature handled it, there were no issues, right? 4 counties got changed. Why? For partisan political purposes. We all know exactly why that happened, that the members of the General Assembly did not like what 4 counties were doing, and so in essence, 4 counties' maps were hijacked by this body as part of that. So regarding the bill in particular, let's talk about that. If you say the bill is just codifying, just clarifying existing law, then it's an unnecessary bill. And if somebody has an issue, they should take it to court and let the courts decide under current law, under current constitution, what that is. If that's all the bill does is clarify, it's not needed. But on the other hand, if you tell us that the bill does in fact enact new provisions, then we strongly oppose it because it goes against the idea of local control for county redistricting. So that's our position on the bill.
Thank you, sir. Okay, because we're out of time for the discussion, if you would like to submit your written testimony, you're more than welcome to do that and submit it to my office. We'll stick around outside after the meeting is over so you can get our information. Is anyone ready to? I'll entertain a motion if anyone's ready.
I motion that we table.
You got a motion? Yeah, you motion. Yeah, you motion to table, and we just have to have a vote on the motion to
Okay.
table.
Okay, so we have a motion and a second to table. All those in favor of tabling, raise your hand. All of those opposed to tabling, raise your hand.
You,
I broke it. Okay,
motion fails.
that motion fails.
Madam Chair, based solely on the purpose of Senate Bill 124 restating constitutional limitations, which are obviously unclear throughout the 159 counties, I do make a motion to pass on SB 124.
We have a motion and a second. All of those in favor?
Discussion. So if it's unclear and the process has worked, I'm not sure why we are trying to change it. Secondly, this is not going to the local delegation. Third, if we're drawing people out of their districts while they're in their seats serving, that is absolutely unfortunate. forth, if the citizens of Cobb County have spoken, we should listen to what their sentiments are, and that is my discussion, for the record.
Thank you.
Madam Chair, under discussion. The purpose of my motion is because SB 124 clarifies what the Constitution of Georgia says that has been upheld in multiple case law. And so thereby, if there's confusion, then I think we clarify that confusion. By doing this, this is not Cobb County specific. This is not any delegation specific. This is Georgia specific. Thereby, I encourage members to support the do pass motion.
Thank you, Madam Chair. I agree with the whip on this one. If it's just restating the Constitution, I don't see an issue. If any member wants to bring an amendment that said, hey, for the term until the end of your term in 22, you're fine, and that's going to be the new state of Georgia law, I'm open to that amendment, but I haven't seen that. And obviously, y'all know I'm a threat to do amendments on the floor. If anyone has a question about how you draft that amendment, I'm happy to consider helping them draft that amendment. The desire is not to draw someone out, and if we can make that more clear, as Mr. Morelli has already stated, I think that's the thought. The issue is whether or not the Constitution of Georgia says who draws the county maps when a county is clearly a subunit of the state government. 124, I don't think is the fight that it's being led to be.
I agree, Madam Chair, completely. You nailed it.
All right, I think we're ready to vote. All of those in favor of the motion to do pass, raise your hand. Oh, sorry. Yep. All of those opposed? There's a tie, so I vote in favor. All right, the motion passed. We're going to stand in recess until a later time to take up this second bill on the agenda.